to talk about how to brief a case in law school. In general, we recommend book briefing as the primary form of case briefing that you use throughout law school. And we'll talk about that when we discuss book briefing. But briefing cases in general, whether you book brief or write out a full case brief, has benefits. For example, it will make you more comfortable when you go to class. It will help you learn how to read and dissect a legal opinion. And it will help you, to an extent, in learning how to think like a lawyer because you're going to see what facts the court relies on in making their decision. So it is a really good learning tool to prepare for class discussion. One thing it does not do is it does not help you much on a final exam, since the final exam most likely will not test cases. So it is really only one of the 5 things you want to do throughout the semester. The other 4 being outlining, learning the law, learning an exam taking strategy, and practicing that strategy. Here, we are going to start by talking about how to write a full case brief so that you can understand the basic structure. And then we're even going to go through a few cases together. So first, you usually put your case name at the very top of the case brief so you know what case you're briefing. And then you state the facts. A lot of people make the mistake of trying to say all of the facts in the case, and they provide a really long, detailed fact pattern. But this is supposed to be a case brief, so it is supposed to be short, it is supposed to be brief. So instead of providing a really lengthy rendition of what happened, just try to summarize the facts in a couple of sentences. The more concise you are, the better. Because then when you look at your case brief, you'll know exactly what happened in that case. You won't have to basically read the case again to figure it out. Second, the procedural history. State what happened at the lower court levels. For example, maybe your case is in the trial court and the judge made a decision and then the lawyer appealed it, so now it's at the appellate court level. The procedural history is honestly not very important to your understanding of the substantive law in most cases, except in your civil procedure class. So generally, that can pretty much be ignored unless your professor frequently talks about the procedural history in class. Next, the issue. So state the question that the court needs to decide in order to answer the case. Maybe the question is, did the defendant commit a battery when he punched the plaintiff in the nose? Maybe that's the entire question the court is deciding. And it's best to write this in a question format. It's best to have a question mark at the end of the issue. And it's best to be written in a yes or no question format. So, did the defendant commit a battery when he punched the plaintiff in the nose? That would be a yes or no question, and that's typically how these issues are written. Next, the holding. The holding answers the issue presented before the court, typically in a yes or no format. So yes, the defendant did commit a battery when he punched the plaintiff in the nose, or no, the defendant did not. Next, the rule of law. Identify the rule of law that the court uses to answer the case. The rule might be, in our hypo, a rule about battery. For example, the rule statement might be, a battery is an act with intent to cause a harmful or offensive contact or an imminent apprehension of that contact, and a harmful or offensive contact directly or indirectly resulted. This is probably the most important part of a case brief because this is the rule that you want to memorize for your law school final exam. Then next is a rationale. So answer the question, why did the court decide to rule this way? Sometimes the court relies on facts, sometimes the court relies on one interpretation of the law rather than another. Sometimes there is a policy decision that will lead the court to rule in a specific way. And then, if there's a dissent or concurrence, put a short summary. Sometimes there's a dissenting judge, and they'll say, I disagree with this court's opinion because of X, Y, Z. A concurring opinion agrees with the outcome, but has a different rationale for the outcome. So it can be interesting to read the dissenting and concurring opinions. So that is the format of a case brief. Next, let's talk about some general tips. First, keep your case brief short. Do not write more than 1 page. And try to summarize what happens in your case in your own words rather than just copying directly from the case. Otherwise, you're probably not really digesting what happened in the case, and it might be hard to reference your case brief later. The whole point of a case brief is to have something really quick you can reference if you want to remember what happened in a certain case. So when to brief a case? As a general rule, we recommend book briefing rather than writing a full case brief for most of your classes. But some students find it helpful to write full case briefs in the very beginning of the semester for certain classes, or if they are worried they will be called on. Next, we'll practice writing a few case briefs and we'll talk about book briefing cases.